Welcome to Tangents from Coin Center. I'm Jerry Brito, and with me today, I'm very happy to have Kirupa Pushparaj, who is head of intellectual property and legal operations at Square. Thanks for being here.
Thank you, Jerry. And I have to say, not many people get my name right at the first shot, and you're one of the few people. So thank you for that. It's an absolute pleasure to be here. Thank you for having me over.
My pleasure. So we're having you on today to talk about something that Square announced a little while ago that I was very happy to see. And that's something called the Crypto Open Patents Alliance. And while Square, and in particular you, I think, helped create this organization, it's not a Square-specific thing. It's its own organization. And I'm hoping folks will learn about it, and if they're in the crypto industry, maybe join it. So maybe we can begin with your background. What do you do at Square? How'd you get there, and what do you do? And tell us about that.
Perfect. Absolutely. So I am an engineer by training, and I put my engineer hat on first every decision I make, I guess. I was at Intel doing circuits and software engineering and went to law school part-time because I am very interested in the intersection of technology and policy and law, which comes with it, and where there needs to be a balance between technology and policy, and how technology policy evolves with changes in how we see its landscape, especially in technology, right? As we see with blockchain, how things have changed with AI, ML. So this is definitely the sweet spot for me, and completely enjoy being at the intersection, especially as a patent attorney. I worked at a law firm for a number of years and then worked for Amazon and came to Square about 7 years ago, which seems like a lifetime ago, but also feels like just yesterday, to start the IP team over here within the legal organization. So really take on the aspect of protecting IP, but in a sensible and in a manner that benefits the community as a whole, and also to deal with all the litigation that comes from patent trolls and patent aggressors going after companies, startups, young companies like Square back at the time, and all other companies, which to me is really a tax and a bane on innovation, patent trolls, patent aggressors, and taking a strong stance from a policy perspective, how we react and address those from Square's perspective. That's been a lot of what I do at Square as well. And then also from a technology and how law interacts perspective, taking good stances and principled positions on how we deal with open source, how we give back to the community, and how we protect our IP as a whole. So that's been a large part of what I do at Square.
And so at Square, I imagine, so you head up the intellectual property, basically practice at Square. And I imagine most of that's going to be patents. It's going to be a little bit of copyright, a little bit of trademark, but I imagine it's mostly patents.
It's largely patents, but as you can imagine, a company that's in such a consumer space, there's a huge number of trademark issues. For example, on Cash App, it's a very popular product, but that also leads to a lot of scammers on popular social media. So from a trademark perspective, other IP perspective, addressing issues that affect our consumers and people who use our products. So it's a good balance of everything, but patents definitely takes up a lot of oxygen for sure.
And so within patents, obviously you've got, Square has its own patents, and it's going to be enforcing those patents. But what would you say the balance is between sort of standing up for your own patented ideas and defending patent claims against you?
I would say it's about an equal half.
Oh, wow.
From a protecting patents perspective, we're not the company, and I wouldn't want to work for a company that builds a patent portfolio just to go after people, just to keep people from doing something. A sensible way of protecting your IP and building a patent portfolio is to build what we call a defensive patent portfolio. In protecting what we do, in making sure that we're not blocked by others in offering the products and services we offer. And to the extent an aggressor comes after us, we have a defensive weapon against them to keep them away from suing us. So that's a large part of how we think about protecting our patent or protecting IP and building our portfolio.
And maybe we should take a step back even before we get to the alliance, and maybe just explain for folks, maybe not what a patent is. I think people have a good idea of what a patent is, but I think people don't realize what software patents are and how malleable they are, I guess might be a way to put it. Do you want to just quickly, briefly talk about that and what, and how they can prevent others from just doing anything if they fall into the wrong hands?
Yeah. I also teach patent law, so forgive me if I go into professional mode every once in a while. But the whole concept of patents and the philosophy behind it, when the framers came up with it, was to really motivate and support innovation, not to keep people from doing things. So if you look at the very policy behind it, it's, hey, I want to do something that benefits the community, create the first drug that cures malaria, cures every heart disease there is. So I'm not making that for myself and my personal benefit, but I'm actually giving that to the society. But I need to also be compensated for the time and effort that I put into innovating and bringing that to market. So, hey, here's 20 years of monopoly for you to recoup your investments and the monopoly and the innovation you put into doing something that benefits society. After 20 years, the fundamental is that the whole world gets to enjoy that for free. It's something you've given to the society for, well, the country based on country laws. That's really how patents are supposed to work. And this makes sense for the pharma industry back 200 years, 300 years ago, how it was framed. But in the software field, it's a very, as you say, malleable concept. Things that are developed today and patented today become obsolete in 3 years, 4 years from now. And the notion of protecting something for 20 years is at odds with the whole point of giving monopoly for 20 years. Also, a lot of software ideas tend to be what in the legal world we say abstract, which is also the very English word of it. You tend to try to protect things that are, what you could do in your mind. In a typical example is, in a stock market, I'll look at how things vary on a day-to-day basis and I'll hedge my bets based on this algorithm. And it's simple, I'll look at what goes up, what goes down, and I'll buy new stock. And someone tried to patent that, and claiming that that's something that's done on a computer, so it's a software technology, and so they need a patent.
It's like an obvious idea that we've known about forever, but the moment you instantiate it in code, it becomes patentable.
Exactly. So code should not be a magical operative word that takes something that can be, as you say, super obvious, even if it wasn't immediately obvious, something that can be done in a human brain, and take that very intangible thing and just say, it's on a tangible computer, so it should be patented. Right. And in the 80s and the 90s and even the early 2000s, a lot of these abstract ideas went into patents, and that's what we're reeling with the effects of right now. A lot of these patents are now being asserted. The whole mechanism of patents back then, companies file for patents, become bankrupt, or go out of business.
These are real companies, startups. They have ideas. They get the patent because it's a good idea to get a patent.
Yeah.
They're a startup. They try their business. It doesn't work out. The .com bust happens. They go bankrupt. And one of the few assets that they have left are patents.
And they end up in what's now become the politically correct term is non-practicing entity or a licensing entity, but I will use the word patent troll or phrase. It ends up in companies that don't operate in that business, but just hold these patents for the purpose of going after companies to get licensing revenue.
So these are firms typically made up of lawyers who go around, buy patents from all different sources, and then they don't use the patents to build anything.
No, just
they
to go
use the patents to go and sue people who are in that industry and basically shake them down. Say, look, it's going to cost you this much to get a license from us, and if not, we're going to sue you.
I'll get to that in a second. But in terms of the companies, those companies that went bankrupt or otherwise built the patents in the first place, right? Why do they even do that? So it's a system feeding into itself. Everyone else is getting patents.
Right.
I need to survive, and all software is patentable. So I don't want to be the only company left behind. And if I'm trying to raise funds for my company, Series A, Series B, VCs are looking into whether I have patents as patents somehow got translated as, oh, that's the seal of whether you're innovative or not. I don't think patents means innovation. It's a sign of innovation. Doesn't become the only mode of showing what your innovation is. So that's why they built their patents. And now those patents get fed into these companies. And as you say, yeah, these are companies that essentially are comprised of lawyers or licensing executives. They just buy the patents, have no interest in productizing it. You buy patents with the intent of, okay, it's a useful product. I'll create this product. And at least I'm backed by a patent. No, that's not the intent. They get the patents, don't do anything with it other than to go after companies. And even with that, there's ranges of trolls or hierarchies of trolls, all the way from ankle biter to the more serious and nefarious ones. There are the regular run-of-the-mill troll doesn't even care what the patent was actually drafted against. It might be a patent that's, it's about how in a hospitalized system for a certain type of a protocol, you have messaging sequences which have inbuilt security. A lot of complexities. That's what the patent would be about. Somehow they get a very broad, what's called a claim within the patent, allowed from the patent office. This is from a real world example that affected us. And suddenly the claim is, you have a server that sends a message to your client, and that happens to be a receipt. So you're infringing the patent. You don't even know what this patent is about. And you know that if I take it to court, either I will invalidate this patent or show that we don't infringe this. But that's not what they're after. They're not after the true merits. They're like, I know it's going to cost you $1 million to just legally defend this in a court. So pay me $100,000. It's so easy for you to just do this $100,000 settlement and get rid of me rather than go through the expense of the lawsuit.
So quick question. So I imagine you must get letters almost every day, probably, of this type. My question is, so they're counting on you not wanting to go to court, but what about them? If you say, no, let's go to court, do they simply drop the matter? And is there any anti-slap kind of protection available?
Sadly, first, super impressed about anti-slap and you mentioning that. A lawyer by training?
I'm a lawyer too. Yeah.
Oh, okay. Sorry.
Okay.
Sorry.
Not that impressive anymore.
Doesn't really play a huge role in patent lawsuits. Ultimately, it's a guaranteed right given by the government. And so it doesn't play a huge role. But here's what happens. They come and sue you or send you a letter asking, demanding that you settle with them. The first couple of times, let me take a step back. I'm fortunate to be in a company where we believe in IP rights. We believe in IP rights of others, but we will not settle down for baseless claims and invalid patents being asserted against us. So we took a strong stance, and a number of companies do this now, against every patent troll. I would rather spend the money to kill this patent because it is completely destroying innovation. Yeah. And it is a benefit not just to us, but to our community and the industry as a whole. I will spend the money to kill it. And we took that stance the first 5 times, 6 times, to even the trolls coming and saying, this is so unreasonable. The funny story I've had is, I'm going to go complain to your CFO and CEO that you're squandering away Square's money instead of taking a license. Like, please do.
Amazing. Yeah, but clearly you want to get the reputation of not negotiating with terrorists, right?
That is a good point to come across, to put across. And we built that reputation. And when a troll calls and says, hey, settle or give me this license, look at my history. I will take you to court. This is an invalid patent because we've researched this. This is not something we do, and this is an invalid patent. We will take you to court rather than settle with you. Now people know that we're serious, just the track record to show that, right? Yeah. And so some of them drop out, some of them still go through. We have a number of cases going on right now where we are putting that very
principle to work
with terrorists, or the principle we're staking it.
Okay, so I think we've nicely laid out the problem and the problem of patent trolls. So maybe we can talk about how that applies to crypto. So what is the issue? I mean, so crypto is a software. How does it apply?
All right, so we'll talk about crypto and then COPA. So crypto, especially as a technology, was really born out of open source, the open source movement. It was meant to be something that's developed together by collaboration of like-minded individuals, companies coming together, and for products to evolve from that collaboration and innovation to build on top of each other. So especially in this industry, to put patents on foundational technologies, the very building blocks of what crypto is about, seems very antithetical to the whole concept and the core of what crypto, the blockchain movement was, crypto movement was. So we wanted to have something that addresses that concern. And taking one step back, from Square's perspective, yes, I am Square's lawyer and I need to do things that are in the best interest of Square's. But as you, I'm sure, very well know, Square's taken a number of steps, especially in the crypto industry, to help the community and help crypto be more successful and add to the innovation. Some examples, we formed the Square Crypto Division about 2 years ago, which I'm sure you're very well aware of. And the whole concept and notion of that team is to develop open source technology or technology to the benefit of the community, add to the crypto or Bitcoin core, and truly, not for Square, but for the benefit of the Bitcoin community, develop products and bring it about to life. It benefits everyone, and ultimately, yes, it will benefit Square as well as being part of everyone. On a similar stroke, I'm sure you've seen news from 2 weeks ago on how we've invested in Bitcoin, actually buying Bitcoin to further fuel interest and growth in the industry. On a similar vein, the Crypto Patent Alliance is something that addresses another aspect, patents becoming a thorn in everyone's shoes, in becoming an issue later on. We're still at a nascent stage where people are just about filing patents. Patents haven't been asserted in as much ferocity as you see in other industries. We've had a couple of patent lawsuits already in crypto, but this is a stage where we can do the right thing and protect at least the foundational building blocks, the basic crypto technology, for preserving that technology for everyone to be able to access and use to further grow crypto. We need crypto not to be contained and constrained. This is not a super evolved technology like 5G or any other industry. We need growth to come in here. This was born out of open source, and we need to remove obstacles, not create them. And the whole intent here is to remove patents as an obstacle at an early stage. So at least that is out of the way. So that's kind of the background there.
Yeah, and it's interesting with crypto, it's not only open source, right? You have open source software, but it's also an open network that everybody joins, right?
Yes.
And so it's really in the best interest of everybody's best interest. Not only that, the people work on the software. So, for example, I'm very glad that Square, like some other companies, are sponsoring Bitcoin Core developers to contribute to the open source. But also the growth of the network is dependent on everybody being able to join it, so that rising tide can lift all boats. And so, as you say, nonetheless, the ideas that underlie this software is being patented.
Yes.
And it's being patented by all kinds of people. So anybody who's been paying attention to the cryptocurrency news for the past 10 years has seen banks filing for blockchain-related patents. You've seen companies in this space like Coinbase and Square and Blockstream file for patents. You've seen random people who assert that they have patents.
You know who you're talking about.
And so, I think you would say, and maybe you'll say it in a minute, but a lot of the companies in the space who clearly have been acting in the best interest of the technology by contributing to the open source, by ensuring that the open network remains open, they're acquiring patents defensively, right? Because they need to have, well, maybe you should explain that. What is a defensive patent, and why do companies, why does Coinbase and Square acquire patents on this technology that they believe, after all, should be open and available to everybody?
Like I said, it's also feeding into the system as it currently exists.
Yeah.
Right now, what is a defensive patent or a defensive patent portfolio? To the extent you're developing something, be it open source or other types of software or any technology, you want to make sure that when you offer it to your customers or others to use it, that they're able to use it without hindrance by others. Mm-hmm. It's almost a common phenomenon that once a company starts innovating in a space, there's a bunch of people filing patents in that space. And America is a first to file country. So whoever files the patent first, not innovates first. First to file a patent, that's the right. Whether it's a proper right or not is later decided at court. But for everything you create, there's dozens of people creating patents in that space, potentially blocking you, or with the ability to block you from offering the very innovative products that you're putting out, not just to the benefit of your people, your consumers, but for the benefit of the community. There are places where even open source software that are released by companies in faith and with good intentions get. When I release open source as Square, obviously, even if I have a patent around it, the open source licenses take care of any patent issues that might come from me. But it's not going to protect someone using the open source from another party, third party, having patents against that technology, who may have developed it independently or nefariously. And then you also face the world where not everyone's building a portfolio for defensive reasons. Some folks, even in the crypto industry, as they have very overtly, explicitly stated that they will use their patents against others if it doesn't fall within their philosophies. You have parties like that. And oftentimes the best deterrence you have against people suing you on patents, or the best leverage you have against other companies that sue you on patents, is having your own patents. That's what brings the balance in there, and you're not lopsided in, oh my God, there's millions of dollars against me in potential damages.
So having your own patents helps you how? Helps you because it's a mutually assured destruction where you could assert your patent against them? Or is it also something to do with showing that you do have a right to do certain thing?
Three things. The first thing you mentioned is probably the most important. Obviously, you don't always have such a patent against someone, but if an operating company comes after me with their patents, the fact that I have a patent against their product is the mutually assured destruction. You potentially have the same amount of damages that you're seeking from me. Right. So let's go stalemate. Let's go our own piece.
Cross license or whatever. Yeah.
License. Oftentimes, it's a very good tool for cross licenses, even for good purposes. Oh, you're building some new technology. I have some technology, so let's cross-license. We're both benefiting from this. That's number one. Number two, it's happened to Square a number of times. It's often, if you were the first person to offer, first company to offer a product like this, it's also evidence of you having been the first innovator, and keep others from filing that space and claiming something that's not theirs to be their own. It's number two. And just the deterrence aspect. Oh, they have a lot of patents against them or in their company, and they will come against me with one of their patents. So I don't even want to deal with them. Let me go after someone who I'm not going to be so worried about. So the deterrence aspect, even before coming into aid during litigation, the deterrence aspect of having that nuclear arsenal, not that I'm going to, is a very important consideration.
Right. Okay, so let's finally get to the Crypto Open Patent Alliance. So we've got all the pieces. So, okay, you've got all these different firms in the crypto space, in Bitcoin, committed to Bitcoin's success, Coinbase, Square, Blockstream, many others, they all have their own patents for good defensive reasons. But boy, wouldn't it be cool if they could all join into one big Justice League and pool their patents together so that one's patent basically becomes available to everybody else. And that's what COPA basically aims to be, right?
That and some more.
Okay.
I'm more an Avengers person than Justice League. We'll go with Justice League for now. You have a very strong grasp on this. Thank you for that. And it's also a good place to start from. So we've talked about all the building blocks and some of the considerations about how patents could be used defensively, right? So seeking to address that in two manners. So COPA is really Crypto Open Patent Alliance, we abbreviated to COPA, really goes after two things: to essentially bring down the potential and incidence of patent litigation. That's the primary effect, and have the technology available for people to innovate and be carefree about potential incursions. So the first aspect of COPA is what we call a patent pledge. This is something other companies like Blockstream have also done, and it's formalizing that in a broader manner. So what this does is essentially anyone who joins the membership, to the extent they have patents that are foundational crypto in nature. By the way, we don't discriminate cryptocurrencies. Bitcoin is great, but every currency is great as well. So it's cryptocurrency in general. To the extent they have foundational patents in any cryptocurrency, they pledge never to use it aggressively, offensively against not just other members, but any crypto product, any crypto developer. So it could be a person, a company, anyone. And the only times they're allowed to use it, the exceptions are, one, if they get sued, that's the ultimate purpose of a patent portfolio. That's also what you would typically find. We also want this to be truly a community network effect and protection of the community, not just oneself. So the second exception is not just if I get sued, but if anyone in the crypto industry is sued by such an aggressive offensive party, I can either give my patent to them or I can counter-sue them on their behalf. So kind of using for the benefit of others who are affected by
who aren't even members of the alliance.
Yes, it's about the community.
It is a true Justice League.
I don't know what you have against Avengers, but sure.
No, I'm just a Batman fan.
Fair enough. And so those are the two primary aspects. And then, so that's the patent pledge. And then this legally, I would say, innovative concept of the shared patent library. Right. So again, going towards the Justice League aspect of protecting the community, where taking one quick step back, we talked about how one of the best benefits of patents possibly is that it offers deterrence value against people being sued in the first place. So if I have a large patent portfolio, the chances that I get sued are low by an aggressor. So that's great for companies that have patents. And with a patent pledge, everyone's going their own way. I want to sue patents. But what about the companies that don't believe in wanting to have a patent portfolio or don't have a portfolio, the smaller startups, which are truly driving so much innovation and new product growth in the crypto industry? So this is to address that concern as well. So regardless of whether you have patents or not, if you're a member, you have access to the collective pool of everybody's patents, whoever has patents, as a shared patent library. And if any of the members get sued, then they are able to access one of the other members' patents to the extent it applies against the troll or the aggressor who's against them, and use it in their defense. So by doing that, there's two advantages we try to get through. One is, even before litigation, even a company without any patents has the notion of a strong, large portfolio in their possession that operates on its own as a deterrence. And two, even if you have patents as a company or don't have patents against a company, you never know which patent is going to be useful against that one aggressor who comes after you. So you have a larger swath of patents to choose from, and so that defensive value only gets better. So it's going to be beneficial both for companies that don't have patents, don't ever want to file patents, or the companies that actually do have patents, but maybe don't have that one patent they need when the time comes.
Yeah, that's amazing. So if you're a firm working in the crypto space, whether you have patents or not, you can join and benefit. So this gets to a question of the organization itself. So
quickly, one thing I forgot to mention is so the effect of both. We talked earlier during the discussion about patent trolls, how they get the patents from these bankrupt companies and everything.
Oh yeah, this is good. Yeah.
So this also indirectly or possibly directly stems away these patents from getting there. So we're early enough in the crypto phase of patents that with more and more companies joining in Canada, placing that encumbrance of the patents that they will never use it aggressively, it goes with the patents. It doesn't go with the company, it goes with the patents. So even if the company goes bankrupt, and I hope none of these companies go bankrupt and are all thriving and successful, if for any reason they go bankrupt, if the extent they have any patents go to the hands of patent trolls, these patent trolls still cannot assert these patents against any of.
It's like an encumbrance that's put on that patent. And whoever buys it in the future can't buy it without the encumbrance. And the encumbrance says you can't use it offensively. So it's useless to a patent troll to acquire in the future. That's
exactly. So it addresses all these concerns. And since we're early enough and with more members joining, we place this encumbrance on a broad portfolio such that it doesn't become a patent troll issue later on as well. And from all this, you obviously get that with more and more members joining is where the true power comes from.
So I wanted to talk about the organization then. So as I mentioned early in the conversation, this is, you're at Square, you helped drive this with the help of other folks in the community and helped launch it, but this is not a Square division. This is an independent organization that Square is a member of. Is that right?
Exactly. We do not want this to be Square driven from an organization perspective. We saw the need for or the opportunity for leadership to create something that the community is definitely asking for, and the luxury of having the resources and the leadership from Jack Dorsey and our GC, Sivan Whiteley, to be able to create something like this. But it was meant to be for the community and driven by the community. So yes, we put in quite a bit of money in developing the legal constructs and the organization. We will fund it for another year, all the operations and everything from paying taxes to the extent we have to pay taxes or whatever be the case. But the organization will be run by an independent board of 9 members. Of the board too, we were very careful about thinking about how the board should be structured. We have 6 member boards of companies that are member organizations, and even that with the diversity of mining versus wallet versus exchange companies, and reserve 3 seats for truly independent members who are not necessarily member organizations, but people who are open source and community champions.
Right.
We've already talked to a couple of people who would be great, but again, we don't want Square making those decisions.
Right.
We will form the board first, and that will be a board decision on how we even board the community.
So eventually, organization will be completely independent. It'll pay for itself, or through membership dues or whatever. Question: so what criteria will it use to determine whether somebody can join or not? Like, what's the membership criteria?
For this to be successful, we cannot create criteria or block people from joining. As long as you have the notion that you might have a crypto product or you're in the crypto space, you're welcome to join. You do not have to have any patents already to your name or ever have to file patents. Only to the extent that you may have patents in the future, they come under this encumbrance and the network effect.
You have to agree. You have to agree to the pledge.
Exactly.
And to accepting the encumbrances, and obviously you might have to pay dues if that ever becomes a thing.
And even that, we wanted to be sensible and
Sure.
we want to join. So for companies that have under 10 million in net revenue annually, no membership fees, they're free to join, which is a great benefit for the smaller companies.
Sure.
And we cap the membership fee at $20,000 for companies having more than $100 million in annual revenue. Didn't want this to be so. The membership fees being kind of a deterrent for people to join. And all the decision making, again, is going to be through the board. Square will help run from an operations perspective just to support the organization, but the decision making is vested with the board.
Got it.
And there's no other. Some people have asked me, could there be a patent troll who joins the organization? And will you say, actually, that's great for their patents come into play. And truly, for this to be successful, we cannot discriminate or place any constraints against who is able to join, even if they're nefarious actors. In fact, it benefits the community, and it's all about whether they're in the industry or not.
Yeah. So here's a question I like to ask guests when I have on and they're making a case for something. It's try to steelman the other side. What's the best reason why a company would not want to join something?
Obviously, it's something that we put a lot of thought into while building this. There's two kinds of companies that may have different kinds of concerns. One is a company that's a large company with a large patent portfolio of their own and worrying that some random company affected is going to steal my star patent. It is a true concern, whether it's placed, whether it's in good intentions or not, that might be a concern. So we didn't want COPA to be a police state such that if a company joined, your patents are automatically pulled out of you. It's the companies that want to truly share will share, and the companies that do not want to share will come up with a reason not to. But we placed kind of safeguards around that. If it is reasonable for you to be able to share and you want to share, you can share. If from a business judgment perspective, if it's not reasonable or otherwise you're unable to share at that particular moment, maybe you are expecting to be sued yourself, or that particular patent is something you're using for fundraising, or otherwise you think there's concerns, you're not going to be penalized as a result of that. So there's still some leeway for you to be able to reasonably not able to share if that is the case. So again, not making this a police state, but making this truly a network of organizations that want to come in and play to the benefit of everyone in the community. And you're able to do that, great. If you're not able to, okay, no worries. Even if they're not able to share, the fact that their patents are in the presumptive umbrella of patents that operate as a deterrence by itself gives the benefit. So that's fine. So that's one reason why companies with large patents might hesitate or think about this a little. The other kind of questions we're getting is some companies, and I love these companies that they're being so nice about this, are like, we don't have patents or we'll never get patents. We don't want to be considered the leeches who come in and take advantage of something that's what we're contributing to. Like, A, you're super nice to think about it. And B, that this is truly about the community and everyone coming together. And we never know how your management is going to change or what changes in the future for you. You're making an early commitment to protect that value that you want to protect, that you'll never want your patents or never want patents, or if you do have patents that won't be used nefariously. So in a way, you're actually doing that more concretely. So surprisingly, that took a little more convincing for people to say, you're not doing a bad thing, you're not leeching off, it's okay to join, and the other situation.
So you're definitely contributing something in that position because you're committing yourself, and that's of value. So it's interesting you mentioned maybe a firm with a large set of patent holdings. Is there any room for negotiation about what is included and what isn't? Because I can imagine, just off the top of my head, JP Morgan, they've got blockchain patents. Maybe they want to join, but I'm sure they have hundreds of years of patents. Well, I guess 20 years is only the thing that matters, but that they would be concerned that would get touched here.
Absolutely. That's something that was very much part of the construct, the initial construct. This alliance and the patents subject to the alliance are only your foundational crypto patents. We have a clear definition of what counts as foundational crypto patents. It's only about that. If you were to pull in all the technology, this would just fold and fail at the very start of the.
And when you say foundational crypto patents, you mean what? It's patents that have to deal with the protocol level.
So protocol, coin storage, crypto mining, things that enable you to better build better efficiencies for network effects. There's a whole list out there, and mostly around the architecture, so protocol itself, and things that you would look at as these are the building blocks I need to be able to offer a new crypto coin or be able to offer a better way of transacting with the coin that people can build business applications on top of. Right. This is a definition that we put a lot of thought into, and all the candidates that we're looking at for independent members got it vetted through a lot of people. And I think we came at the right balance for where we cut off a foundational crypto patent. So a company like JP Morgan, not that I'm picking on a particular company, company with a large portfolio can benefit from the notion that this is only certain patents that fall under the category.
Okay. Well, I mean, I don't know why any serious firm in this space would not be joining. So, for what it's worth, I think that everybody should join. So where do they go to join?
So right now, go to the website, open-patent.org. There's a contact us section, and that's the best place to reach out. We're still building a lot of the background elements, and we're in the process of forming a board once we have an initial quorum of members. We have about 12 members signed up so far, which far exceeds our expectations already. By the end of the week, we'll make an announcement as to the larger members, all the members who've joined so far, and also announce the formation of our board, hopefully in the next week or two. But people can reach out through the website. We've had, over 50, 60 companies reach out already. So that Square is also being altruistic in a way in helping hire another person to my team who will essentially be charged with running the operations for this organization. So once we have that additional resource, we're able to do more and respond faster, but we're charging forward with everything we have at the moment.
Well, that's awesome. You're doing great service for the community. So thank you for that. And Kirupa, thank you for coming on Tangents.
Thank you very much for having me, or this was a lot of fun for me.